The Center for Progressive Reform harnesses the power of law and public policy to create a responsive government, a healthy environment, and a just society. The center envisions a government that uses the full force of its power to curb climate change and ensure a sustainable environment, economic justice, and healthy workplaces and communities for all. You can find additional information about the Center for Progressive Reform at progressivereform.org. Registrants will receive a link to a 2-minute survey at the end of the webinar. Please complete the survey to help us improve. Thank you again for joining us today. Next slide, please. The Center recently released a brief, Rising to the Challenge, How State Public Utilities Commissions Can Use the Inflation Reduction Act to Advance Clean Energy, introducing the public to some pieces of how PUCs operate and how some states have successfully encouraged their PUCs to make timely, needed progress on just climate solutions. But as a think and do tank, we know that translating policy recommendations to change in the real world has to take place on every level, in communities, classrooms, courtrooms, and other institutions. In our brief, we explore how public utilities commissions can promote the adoption of clean energy while protecting low-wealth customers and promoting social inclusion. It's become increasingly clear that reforming our energy grid is a crucial piece of the puzzle for meeting decarbonization and climate justice goals. But who are the decision makers who have the power to advance or resist this needed change? In most states, they are a lesser-known political body called Public Utilities Commissions, or PUCs. And each commission's willingness to listen to concerned citizens and frontline communities can vary widely. Energy justice campaigns that center PUCs will therefore look different from state to state and require a combination of policy know-how, community engagement, and all kinds of expertise. This webinar is designed to have something for everyone concerned about energy policy where they live. Next slide, please. In our brief, we find that the Inflation Reduction Act is the most robust piece of federal climate legislation ever passed, but it does not address every climate gap. Many benefits are in the form of rebate programs or market-based approaches that would disproportionately direct public spending to homeowners and the already wealthy. There's still decision-making to be done, and the next phase of allocating and implementing IRA funding will take place at the state and local level, across local governments, businesses, nonprofits, community groups, and tribes. This presents various challenges, but also opportunities to fight for democratic, local solutions tailored to communities' needs. PUCs play an outsized role in regulated energy policy in the energy economy. For concerned citizens, developing an understanding of who utilities commissioners are and what they do is critical. Some states, like North Carolina, are lagging behind by not regulating their utilities. Other states, like Michigan, Missouri, and Virginia, have already utilized their PUCs to take advantage of IRA funds, and their citizens are on their way to experiencing those benefits. To that end, we recommend that 1, state legislatures provide effective oversight of PUCs to adopt more stringent clean energy goals in alignment with state climate plans. 2, that public utility commissions fully embrace their roles as regulators of electric utilities to enforce the adoption of clean, affordable electricity for all people in service of the public interest. 3, that electric utilities should incorporate IRA funding in their integrated resource plan modeling process to both save costs and lower costs to customers. 4, stakeholders, such as clean energy advocates and concerned members of the public, should continue to advocate for stronger clean energy legislation like state decarbonization plans. And finally, 5, federal agencies should continue adopting environmental regulations. To learn more, please follow the link shared in the webinar materials. Next slide, please. Today, we have assembled a team of experts to share their perspective on energy justice, from necessary technical fixes that could make a huge impact to solutions for low-income customers and the challenges of building and sustaining mobilization and engagement for the long haul. Our guests include Alexandra Klass, professor at Michigan Law and member scholar at the Center, who will discuss the role of social policy in public utility regulation. Justin Lindeman, a policy analyst with the North Carolina Clean Energy Tech Center at NC State, who will discuss the current status of equitable rate making. And Diamond Spratling, MPH, founder and executive director of Girl Plus Environment, who will explore the critical role of meaningful community engagement in the Public Utility Commission process and provide practical steps for how to effectively engage. Thank you all. I will now turn it over to Alex Klass to discuss the role of social policy in public utility regulation. Next slide.
Hi, everyone, and thanks, Sophie. So glad that CPR is hosting this webinar and that CPR has been doing such great work in the energy space, in the energy justice space, and also focusing on state public utility commissions, which, as Sophie said, are sort of less well known as regulatory agencies, but have a lot of authority and a lot of potential to be doing good things with regard to energy justice and just in this space as well. Next slide. So my sort of remarks today are going to be fairly broad to sort of set the stage and talk about the role of what I'm going to call social policy in state utility commission regulation. And so sort of topics that I'm going to touch on today are low income rates, economic development rates, and then energy justice. The first two were sort of started to be addressed by utility commissions kind of in the late 20th century. And then, of course, energy justice in terms of its growing prominence in front of state commissions is very new, just in the last couple of years. Next slide. And I'm going to draw pretty heavily on two papers. One is published, one is not. So the first one is one that Professor Gabe Chan at the Public Policy School at the University of Minnesota and I wrote a couple of years ago called Regulating for Energy Justice. And then the second one is a new paper that we have that I've never presented. This is sort of the first time I'm even presenting anything having to do with it, not published yet, but called that sort of builds off the first paper and is called Reckoning with Social Policy in Utility Regulation. So I'm going to draw on some of the content of both of those papers. Next slide. So I want to start just with some of the sort of key laws that are out there that govern the regulation of the utility sector, of monopoly utilities. And really, when we're talking about this type of regulation, we're talking about regulation of investor-owned utilities as opposed to rural electric cooperatives and public power, like municipal utilities, which generally are not regulated by either the Federal Energy Regulatory Commission or state public utility commissions. There's some exceptions to that. And you'll see that the language in terms of the statutory mandate to these agencies is quite similar, whether we're talking about federal or whether we're talking about various states. A lot of the language from state to state across all 50 states is quite similar. I picked the two states that start with M that I live in and know the best. So first we have the Federal Power Act. All rates and charges made, demand, received by any public utility, and that means an investor-owned utility, shall be just and reasonable. You see similar language in the Minnesota statute in terms of rates need to be just and reasonable. They can't be unreasonably preferential, unreasonably prejudicial, or discriminatory. And federal law also requires that rates not be discriminatory. You'll see that Minnesota also has right in their rate making statute a focus on energy conservation and renewable energy. Michigan has very similar language. Electricity rates need to be just and reasonable, and also an anti-discrimination provision. Michigan in other sections talks about renewable energy use and energy conservation, but it's not right in the rate-making language. Next slide. So what about this role of social policy? So you will often hear state commissions say, we don't make social policy. The legislature makes social policy and we implement it. Or you will have an advocate that will warn the commission against making social policy. Or might have a court that reverses something that a state utility commission does, saying they are engaging in social policy, that's a bad thing. So for our purposes, I think we first need to, define what social policy is in this context. Of course, in other contexts, it can be much broader. But one focus on this is looking at dealing with future inequities associated with non-energy state and local socioeconomic concerns. So as fossil fuel plants close, there's concerns about tax revenue, concerns about jobs. What's the role of a state commission in dealing with that in some of its decisions when asked in terms of whether a utility should retire a coal plant or should invest in renewable energy? And then our topic for today of energy justice, you could say that social policy is looking, at past and current inequities regarding the provisioning of electricity services to communities, because we know that there are lots of communities that today and in the past don't get as good electricity service as more wealthy communities or as white communities. They have not had the same energy efficiency investments. How's a public service commission or public utility commission supposed to deal with that today? And should they be doing it? Or is it a role for the legislature? So a lot of what we're looking at in this paper is what's the role of the legislature, state commissions, and then the courts in addressing some of these social policy issues in the context of PUCs, and how should they be addressing in their rate making past and future inequities rather than looking at just weighing costs and benefits at the present moment. Next slide. So I think there are some challenges to sort of transparently addressing social policy in utility regulation. As many of the people on the call know, these are really complicated proceedings. They're very technocratic. It is very difficult for non-experts, non-economists, non-engineers to engage. So, we have results that are based on sort of plugging a lot of numbers into formulas. But there's a lot of judgment in there too. And it's hard to see what those judgment calls are and how social policy weaves its way through because it's sort of behind this technocratic veil. And that's something we talk a lot about in the paper. So behind that veil, this idea of cost causation, that the ratepayers who are receiving the benefit should be approximately paying the cost, this idea of a cost causation principle. That's great in theory, but in practice, it's applied very inconsistently and often to the detriment of communities or ratepayers who are not as able to participate in these proceedings. There's a lot of cross-subsidization between industrial customers or commercial customers or residential customers, and we're not supposed to have cross-subsidies, but we know they exist, but they're hard to find again in these very dense technical proceedings. Also, rates are often set based on cost, but who's benefiting and how do we really calculate those benefits? And if we are, creating a formula to do that, how much is it really based in reality, and what factors are being included and not included? So basically, a lot of our thesis is social policy has always been a huge part of rate making. It's just not acknowledged as such. And part of what we're trying to do is make this whole process more transparent. Next slide. So one of the things we talk about in both papers is, how commissions have done this in the past. And one really good example is low-income rates, where in some states, the commission, Michigan is an example of this, the Public Service Commission has statutory authority to set separate rates for low-income customers, utility customers. But in a lot of states, that's not true. And so the legislature's been silent on that. So in the face of that silence, what is the ability of the commission, either on its own, or in response to a request from a utility to create a low income rate? And this is where you get these allegations of commission don't engage in social policy. So there's a great example from Utah where the commission wanted to do a special rate for senior citizens. State Supreme Court overturns it, saying you, the commission, are not empowered to act on the basis of social policy. You're subsidizing one consumer group, senior citizens, over another. The legislature can do that, but you, the commission, cannot. Now, the commission kind of pushed back. It made some additional fact finding. It showed how this was lower cost for everyone, and approved the rate much later. And the court didn't overturn it. And I think the commission smartly said in response to, complaints about this, that examples abound to demonstrate that one person's improper social welfare program is another person's legitimate regulation of utilities in the public interest. So really leaning in to that authority it had to set just and reasonable rates in the public interest. Similar issue around the same time in Colorado, where the commission approved a low-income gas rate, and the Supreme Court overturned it. Again, very limited authority to provide financial assistance as a social policy to a narrow group of utility customers when another group is going to subsidize those rates. Once again, this is not on the slide, but once again, the Colorado Commission kind of went back to the drawing board, did some additional work, and ultimately came up with a low income rate that was approved. Next slide. You can contrast this with states, commissions that more freely give economic development rates, so cheaper rates to new businesses that say they're going to come and locate in the state and provide jobs and contribute to the tax base. There you don't see either industry or often the courts trying to interfere with the commission's authority in those circumstances. So we kind of use that as a counterexample. This is also social policy. It's focusing on sort of the socioeconomic impacts of particular ratepayers, just like in the last situation, but saying, oh, sure, the commission can do this. So you see how we sort of have these selective allegations of social policy against the commission, depending on who is benefited and who is not. Next slide. So now we come to energy justice, and others on the panel will spend more time on sort of what that means in this context. But we have sort of some well-recognized tenets of energy justice in terms of recognitional justice, procedural justice, distributional justice, and restorative justice. And all of these are sort of really important principles that state public utility commissions are now being asked to address in their rate making and other decisions. Next slide. So, and I attribute all of the nice graphs and slides to my co-author, Gabe, who had some students, some of his grad students, sort of code and look at when regulatory proceedings start really engaging with energy justice, using that term, applying it in their orders. And you see it's basically nothing until the last few years where you see a huge spike. And I'm hoping he's going to update this data as well. Next slide. This shows sort of where and the intensity of where you are kind of seeing commissions grappling with energy justice. And in a large part, this is because advocates are bringing these issues to the commission, and then the commissions are taking them up. Next slide. And this looks at the type of regulatory proceedings that are dealing with energy justice. And you see, there's a lot in rate cases, but also in resource planning, distributed energy rates, grid modernization, certificates of need, energy efficiency. So it's quite a bit. Next slide. So some states have statutory mandates now for commissions to consider equity or energy justice in rate making and other proceedings. We give an example from Washington where the commission applied its statutory mandate to consider equity and used that as an opportunity to actually adopt those four core tenets of energy justice and saying that is what equity means in this context. So bringing energy justice in that way through kind of an equity door. Next slide. And then there are some states like Minnesota that don't have a separate statutory mandate for it, but as advocates have been raising energy justice concerns in the proceedings, the Minnesota PUC decided in 2023 that it could address energy justice and would require utilities in their rate-making proceedings to address energy justice, relying only on that real general just and reasonable rate-making authority that I pointed to earlier. And even though the utility said, well, let's deal with that in a different docket, the commission said, no, we're going to deal with it as part of our rate-making processes. Next slide. A bit more on Minnesota. After the commission made that determination, then the utility actually was involved in this equity stakeholder advisory group and came up with a really innovative 2-year pilot project to provide monthly electricity bill credits to every household within these U.S. census block groups that have a significant electric energy burden. So you don't have to apply separately and meet a whole bunch of different requirements to get this funding. It just goes directly to the community. And they're able to fund it, or at least they're proposing to fund it out of some of the Yucca Mountain nuclear settlement money that they have. And Excel has a really, I think, very good argument as to why doing something like this does result in just and reasonable rates and is not discriminatory in their proposal. The commission is still considering the proposal. Next slide. I think with that, that's the end, and looking forward to questions at the end, and I will turn it over to Justin.
Yes, hello, everyone. I'm Justin Lindeman. I'm a policy analyst at the North Carolina Clean Energy Technology Center. I will be presenting on the current status and landscape of equitable rate making in the United States, providing an overview of existing types and actions. Before I do that, just a bit of background on what the Clean Tech Center is, for those of you who haven't heard of us. We are a public service center, part of NC State University. And we are dedicated to advancing a sustainable energy economy, supporting clean energy technologies, practices, policies, and we also track clean energy policies and regulation changes across all 50 states and commissions. And we've existed for 30 plus years now and have worked with many different entities from government to nonprofits to communities to academia to even clean energy industry. Next slide. So kind of getting back to the matter of equitable rate making as it stands today and why it's important. I'm sure many of you have seen countless of articles and reports over the last several months about the amount of energy demand that is there and is coming away thanks to the need for additional data centers in responding to AI concerns, electrification, and even tons of new manufacturing starting up in the country. Well, this has also led to, and will continue to lead to more capital investments by utilities who have mentioned in recent resource plans the unprecedented energy demand that they need to respond to, including Duke Energy in North Carolina and Georgia Power, as many are trying to combat load growth, which is load being the increase in the amount of power demanded. Now, these investments have already varied from new gas units to renewables and even modernizing and upgrading the existing grid. This rise in capital investments from utilities, especially electric utilities, has led to increased subsidization by varying customer classes, including residential customers. So to help satisfy the capital cost recovery process that utilities go through, that then allows them to recoup some of their investment. So this, of course, has led to higher utility rates. And in the case of Duke Energy in North Carolina, this is especially important to keep in mind, as the utility is entitled to recoup about 10% of its capital investments from new construction under North Carolina law. Now, amidst of all this discussion about new load and what utilities are planning to do, there is an absent focus on how this will impact low-income customers. So without proper shielding and protections for utility customers, especially in states where they're deregulated or states where there's a lack of competition, increased rates as a result of new capital investment has the potential to compound the already existing burdens that exist, even more so for low-income utility customers who barely have the tools and the financial protections in place to shield themselves from recent and current rate increases that happen every few years, let alone even future ones. So this is where equitable rate making comes in, which is meant to ensure that customers are charged a fair and affordable amount for the cost of electricity. And this type of rate making can provide them much needed protection and support for low-income households as rates increase, and can help by reducing the percentage of income spent on bills, which is considered your energy burden, lowering the risk of late utility payments and unpaid utility bills, and even helping cushion the low-income customers' pockets from future rate increases. And commissions, as well as utilities, can engage in equitable rate making to make sure that such customers can survive through the future cost recovery processes, as load growth isn't expected to cease anytime soon. Next slide, please. So where are we exactly when it comes to equitable rate making? Well, we at the center did some research cataloging the different electric rate discount programs and types of equitable rate making across the country that's either managed by IOUs and or states. In most states, you'll find that at least one IOU that offers some sort of income-based discount, which usually entails providing a continuous or one-time payment to income-eligible customers, or removing the mandatory fixed charge from a bill and just having a customer energy usage charge, or even providing a percentage reduction of the overall monthly bill according to a specific income range, which is also known as a tier discount rate. And there are other variations of what a low-income discount looks like. Besides a more basic discount, there are about 7 states that also employ a percentage of income payment plan, or PIP. A PIP would be similar to an income-based student loan repayment plan, where based on your income level, you only have to spend up to a specific percentage of your income on your utility bill, and that percentage usually falls in line with acceptable energy burden levels for that state. And then lastly, there are also this income graduated fixed charge, which California is currently the only state to have this. This is a fairly new and novel method of equitable rate making, which mirrors progressive taxation, in which the lower your income, the less you have to pay, and is a significant departure for IUs in the state, which did not impose fixed charges before this. But all in all, an income-based discount looks to be the most popular form of equitable rate making, especially from the utility perspective, as this map shows. Next slide, please. So to give you a further understanding as to why equitable rate making is so important and why commissions should consider pursuing it further, I mentioned earlier the concept of energy burden. Well, as you can see, according to the US DOE's LEAD tool, for low-income households using electricity as a heating fuel, most have an average energy burden of at least 6 to 7%. Now, this is 3 times higher than that of non-low-income households. And the Southeast, in terms of regions, is the most energy burden region in the country, especially for low-income electric customers. And in states like Louisiana, Alabama, and Mississippi, it's even as high as 8%, with some more specific areas even having an energy burden higher than 30%. For example, Cook County in Georgia, which Georgia Power also serves, there it's a staggering 37%. Now, to understand a bit more of what all that means in context, the American Council for an Energy Efficient Economy specified that you have a high energy burden if you spend more than 6% of your income on your energy bill. Now, comparing 37% to 6%, that's a staggering difference. And so it's important to understand what energy burden is, and especially as more infrastructure gets built and more cost recovery processes ensue, what the impact that could have on already struggling low income, especially low income electric customers. And I know that this image is a bit blurry, but there's a link towards the bottom, as you can see, to the US DOE LEAD tool that you can kind of mess around with based off of income and other variables. So be sure to check that out. Next slide, please. So moving on, I wanted to provide some more information on 2 interesting examples of equitable rate making in the country, and also talk about the role that state regulators played in each state and could play in others. So the first example is from Connecticut, where the regulatory authority there established a goal in 2019 to advance discussions about affordability in the state, especially for underserved communities. The authority since then has itself pursued initiatives to advance accessibility for energy assistance, even creating an annual review proceeding related to energy affordability for utility customers. The General Assembly then passed legislation in 2020, allowing the authority to begin a proceeding to consider low-income rates, which the authority did do. The authority then started a new proceeding towards the end of 2020 on new rate designs and asked for design proposals for low-income specific rates. And then a straw proposal for an income discount rate design was then filed in mid-2022, then approved in December 2022, and this included a 2-tiered discount rate that had to be implemented by the beginning of this year. So out of those 2 tiers, Tier 1 customers receive a 10% discount on their monthly bill, while Tier 2, who must have an income of up to 160% of the federal poverty line, they can receive a 50% monthly bill discount. So in that case, the commission equivalent in the state was already philosophically inclined to support equitable alternatives and assistance programs, and was given the authority to do more so by the state legislature. Next slide, please. And then the second example is Virginia, which enacted a PIP via legislation that was signed in 2020, which directed the commission to initiate a proceeding to establish rates for a service fee to fund PIP program costs. So a pretty important keystone of the program. The commission then issued several orders between then and late last year, approving the fee rates for Dominion Energy and App Power. In the middle of all that, the General Assembly even granted the commission even more authority to enact rules to oversee the fee collection, and also make sure that the PIP manager, in this case, the state or the Department of Social Services, can functionally operate the program. And the program was later launched in December of 2023. So the commission in this case has a very important role to play in terms of making sure that the core funding for this assistance program is there and that the associated rates are effectively implemented, as well as filling any interpretive gaps that the assembly laid before them. And then as for the actual program, Dominion Ave Power customers, for example, who utilize electric heat will have their monthly bill capped at about 10% of their income or max $100. And at a minimum, customers just have to pay $10. Now, for context as to why this is important in the state and why it will be so important even more so, Virginia's projected data center electricity consumption may grow to as high as 46% of the state's total by 2030, compared to about almost 26% in 2023. That's according to an EPRI study that was released earlier this year. So a lot of investments will be needed to combat that load growth, even if it's not the worst case scenario of 46%. And thus utility bills will likely increase. So overall, as these examples show, commissions have the opportunity to play a significant role in not only driving and supporting the implementation process for equitable rate making and rates, but also investigating further opportunities and rule setting and conducting oversight. And like the example of Connecticut showed, even inspiring the state legislature to do more. So with that being said, I'm going to pass it over to Diamond, who will talk about the role of community engagement in the commission process.
Awesome. Thank you so much, Justin. And I appreciate you for mentioning Georgia, which is where I'm based. So I'll talk a little bit more about that as well. So hello, everyone. Again, my name is Diamond Spratling. I'm a community engagement consultant, author, and of course, the executive director at Girl Plus Environment. I am super happy to be here. So thanks so much to Sophie and the rest of the team for having me this afternoon. So just to give you a quick background of Girl Plus Environment and what we do, we are a national nonprofit that is based here in Atlanta, Georgia. And we basically work to shift the narrative to get more women of color into all aspects of the climate and environmental justice movement, whether it's helping them to secure jobs or to figure out and learn about how they can engage in different processes all around clean energy justice here in Georgia and in other states as well that are significantly burdened. So super excited to talk today, mainly around the role of community engagement in energy policy processes. Again, I'll be talking a lot about some of the work that we've been doing here in Georgia, but also just kind of talk on a very high level of different things that you can do in your states as well to make sure that your communities are engaged as much as possible. And so, as we know, public service commissions or PUCs make a crucial decisions about energy that impacts our everyday lives, such as rate structures, energy infrastructure investments, and the adoption of clean energy, of course. And so these decisions can either help or unfortunately, what happens in many cases, they can harm communities, especially marginalized communities that often are overlooked within those policy processes or discussions. So by involving communities in these decisions, we can ultimately ensure that the voices of those who are oftentimes the most impacted by energy policies are not only heard, but also leading to more equitable and sustainable solutions within their communities. Without community and meaningful community engagement at that, there is ultimately a risk of top-down decision-making, which unfortunately we know has many results in inequities. We can go ahead and go to the next slide. Thank you. So community engagement, first and foremost, must happen at the speed of trust. And what I mean by that is it requires patience, as we know, and a commitment to building these very long-term, genuine relationships within our communities. Trust isn't built overnight. It's a very continuous, long-term process of listening, adapting, listening again, adapting, and including community feedback, but not only including community feedback, but deferring to community and understanding that essentially experiences, personal experiences, lived experiences is a part of the data. It's a part of the information that will help to inform us to better understand how exactly we should be approaching clean energy solutions in a way that is both equitable and representative of the needs that our communities have expressed. So top-down approaches, like I mentioned, can feel very rushed, very dismissive. Oftentimes, we'll come to community and say, "Hey, we want to send out a survey," when they're like, "Oh, well, we just did a survey a couple of weeks ago, but no one got back to us about that survey." And so, being very intentional is very key because a lot of times that's why we get that disengagement because we don't do our homework in the first place to better understand what the community's needs are or their concerns are in the first place. But we know when we engage at the speed of trust, we empower communities to actively shape the policies that affect them. And again, it's no easy task. Nothing in life worth doing is easy, but community engagement is something that is going to take a lot of time. It's very difficult to do. And, I think we understand from the policy side of things that a lot of times we're on these strict deadlines to get these policies passed and pushed. But a lot of times there's also this friction because community needs time to understand what the policies mean and how it impacts them every day. So it's not so much that they don't care about the issues, but more so needing to take time because that's not their specialty and wanting to understand how exactly it will impact their health and well-being. But ultimately, this approach fosters transparency. It reduces mistrust and encourages ultimately a culture of shared responsibility for sustainable energy solutions. And I think that's really key there is really making sure that that public service commissions, public utility companies are being very engaging in that process and making sure that community is engaged from a very shared value standpoint. And I think I'll talk in the next slide a little bit more about what we mean by a shared value, but having that community ownership really does make a difference so that people can feel and actually be engaged in all parts of the process. Um, a quick example here that I have in when we've done some community engagement, and I'll talk a little bit more about this in one of the next slides, but at Girl Plus Environment, we have an entire program called the Protecting Our Energy Project, where we basically engage women of color who are based in energy burdened zip codes or communities. And we do different trainings. The trainings are about 6 months where we compensate individuals to basically come in and learn about energy justice, energy burden, learn about the Georgia Power rate case, the integrated rate case, and really understand how they can be involved in all stages of that work. Because unfortunately, what we found out is that many of our people in our community here in Georgia had no idea what the Georgia rate case was, let alone knowing what their public utility companies were. We actually, fun fact, we did a training just yesterday with Black women small business owners, and no one knew that they actually were the ones that vote in the public service commissioners, and they couldn't tell who their commissioners were. And so that's a huge thing as far as being able to understand and pass down that knowledge. But one of the, I guess, like kind of wins that we've been able to express is the fact that we did one of our cohorts, and before we started the trainings, only 23% of participants even knew what the rate case was. But after that cohort was finished, we were able to say, due to the pre and post test that we had, that 89% of the participants said that they felt both knowledgeable and, most importantly, empowered to talk about energy justice with their community members and to also share that information with others and to engage in the Georgia rate case. So that was a huge win for us. You can go ahead to the next slide. All right, thank you. So to make community engagement truly meaningful, there are several different mechanisms that we have adopted in the past and just other ones that we recommend. So the first and probably my favorite is the Marshall-Ganz framework. And this is basically his story of self, us, and now. I don't know if folks have heard of it, but a really great framework that basically it's a storytelling method that helps people to understand what their personal experiences are in order to get other people to also care about the same thing. So taking a look at yourself to understand Why do I care about being engaged in the clean energy process? Why do I care about energy justice? And then trying to figure out what those shared values are between yourself and your community so that you can better understand. Maybe it's the fact that we're all coming together because our energy bills are too high, but we don't know that there are things that we can actually do. So leaning into that story of self, us, and now is a really great framework to be able to further tell that story and get more people engaged and involved in the work. It's also crucial to recognize that many people don't know that they have a say in their energy rates, like I said earlier. And so it's really critical that we educate communities and provide inclusive communication methods that ultimately cater to diverse cultural backgrounds. And so that's a bulk of what GPE does is we shift the narrative and we translate technical policy information in a way that community members understand and in a way that they will feel confident and comfortable to also speak up and engage in things like submitting public comment, showing up to hearings. And then the next thing I'll mention is the spectrum of community engagement. I actually included a QR code here for you to scan, but it basically spans from simply informing communities to achieve to all the way to achieving community ownership, where people have a stake in their decisions. So I encourage people to go beyond community engagement and lean more into community ownership and deferring to community as well. And then finally, here, just identifying community liaisons who bridge the gap between policymakers and residents is very key in this process of community engagement. And then ultimately, just understanding that community engagement is both a ceaseless and iterative process. And I'll go to the next slide. Thank you. All right. And then I know I already kind of mentioned the protecting our energy project, so I won't go into too much detail, but this was an example of a community-centered engagement. It was designed to really support energy burdened communities and being very engaged in the energy policy conversations, decisions, all of the above. So we help people to pay their utility bills. If they couldn't do that, we gave them technical assistance so that they can plan their own community events around rallying more people to submit public comment, to show up to hearings. And yeah, just really quickly, just a testimony from one of our participants. They shared that the program helped them to move from feeling very hopeless to feeling empowered, and just ultimately ready to advocate for energy justice in their community. So this is the impact of meaningful community engagement and really transforming the narrative and the culture of what it looks like to engage in energy policy. And with that, thank you so much for your time. And I'm going to go ahead and pass it back over to Sophie.
Thank you so much, Diamond. And now it's time for our Q&A. So if you haven't already, please feel free to drop your question in the Q&A box. We already have one here, and this can go to any of our speakers today. What is a rate case?
I mean, I can start. So when we're talking about monopoly utilities, so these are utilities that have a monopoly service territory in what we call traditionally regulated states. So, Minnesota falls into that category. Georgia does. You as as an electricity customer, you don't have a choice of who your electricity provider is. There are service territories that are assigned. So like I have a house in St. Paul, Minnesota. My choices for electricity to who provides me electricity are Xcel Energy, Xcel Energy, and Xcel Energy. I don't have any other choices. And because there's a monopoly, we don't let those utilities charge whatever prices they have because there's no competition and they could charge whatever prices they wanted. So we have what's called a regulated monopoly system, at least for retail rates. And so a rate case is where the utility, and this is by statute, the utility goes to the commission and says, this is how much money we need to run our system this year and provide electricity to everyone. Here are all our costs. We're entitled to earn a rate of return on our investments. And so they open a rate case to decide both how much money is going to get paid to the utility and then how is it going to get divided among different customer classes. So typically residential, commercial, and industrial classes. So there will be a total revenue amount that the utility gets that will be divided between the different customer classes, and then that gets translated into certain fixed charges that you pay on your bill and a kilowatt hour price for electricity. That's a very sort of simplified explanation. But the idea is you have basically almost a trial-like proceeding with in front of an administrative law judge with testimony, lots of complicated sort of economic arguments as to how much the utility comes in with a certain amount of money, and then you have advocates who are arguing, no, you don't need that much money. Your costs have not been reasonable and prudent. These aren't just and reasonable rates, or the way that you're proposing to divide it up is not fair between customer classes. And so that is why it's really important to have a lot of advocacy and groups like Diamonds making people aware of what a rate case is, how important the Public Utility Commission is in deciding what kind of services the utility is going to provide to its customers and how much you're going to have to pay for it.
Thank you, Alex. Do any of our other panelists want to weigh in?
I'll just quickly jump in, specifically, for example, in Georgia, our Georgia Power, our only a utility company for us Atlanta residents, proposed a 12% rate increase. And so obviously a lot of people were disappointed with that. And I think one of the things is the public service commissioners, they were the ones to decide whether or not Georgia Power was going to be able to increase rates by 12%. Ultimately, they ended up meeting at a lower amount, but over time, it ended up adding to be up to 12%. But one of the things too is to understand, where those rates or where that extra funding is going, whether it's going into shareholders' pockets or whether it's, for example, in Georgia Power, they're building their third nuclear plant to try to advance more clean energy stuff here, which definitely has been controversial for a lot of community members. And so one of the things that that increased rate is to do is basically to help fund that nuclear plant, which is now over budget by about, I think it was about $2 billion.
Oh, thank you for that, Diamond. And on a similar note, someone else asked, how do rate cases or other procedures affect promoting clean energy?
So I can jump in. So lots of different ways. So there are oftentimes other statutes that direct both utilities and commissions to address clean energy issues. So sometimes utilities have to engage in what is called integrated resource planning, basically have a 10 or 15-year plan as to how they're going, what resources they're going to use to provide electricity to their customers. Some of it is existing plants that they have, others that they're going to build in the future, and then also wholesale power that they might buy from other utilities or power generators. And so you can have a statute governing the integrated resource, and they have to get that approved by the commission. So you could have a statute that says the presumption should be that you're going to build renewables. And if you, the utility, want to build other than renewables, you have to justify that based on cost and other sorts of things. Then there's some states like Kentucky and West Virginia that basically the presumption is that you're going to provide the electricity based on coal. And it's very difficult to rebut that presumption and say, no, we want to use wind and solar instead. How it might come up in a rate case is, let's say you have a very coal-heavy utility, and they're saying this is the cost that we are incurring to run these coal plants, and we want to recover it from ratepayers. And so advocates, and ultimately the advocates can say, well, it would be a lot cheaper for all of us if you retired those coal plants and instead either built or bought wind and solar energy to provide more of that, because those resources are cheaper. So your rate is unjust. The rate that you're proposing is unjust and unreasonable because there are other ways of providing that electricity that both don't have environmental externalities and are lower cost. So it can come up both in the integrated resource planning process, it can come up in a rate case, and then of course, over half the states have some form of a renewable portfolio standard or a clean energy standard that requires the utilities to provide an increasing percent of carbon-free electricity to their customers. So that's an overlay as well.
Thank you, Alex. Justin or Diamond, would you like to add anything to that? All right,
Can
we
I
have
ask,
another question. Oh,
can
go
I ask
ahead.
a question to Justin? Am I allowed to ask questions too? Justin, I
Sure.
loved your map of the US that shows the states that have low income discount rates and whether they're statewide or whether they're utilities. Do you know how many of those states, even if it's approximate, the low income rate is authorized by state statute or whether it was first developed through a public utility commission proceeding?
Um, I mean, off the top of my head, we do have some, like, we have cataloged that some of that information. Um, I can say that most of the time it was especially in the Southeast where legislation hasn't really been passed to enforce that on the commission or enforce that on utilities. The utilities have worked with the commission through their own proceeding to then apply these new, especially low income discounts. Now, when it comes to like these PIP programs where it's a lot more, uh, I would say comprehensive and it's a bigger program than just a simple low income discount, that has usually been started by state legislation that then demands of the commission to start either a investigation proceeding, which then leads to the commission then deciding, okay, a a PIP is the best way to go. So we're going to demand a service fee or something from the utilities, and then they handle the rate creation process through another proceeding. So it depends, but I think overall, as you can see in the map, most utilities are rather okay with a low income discount, which is a very basic form of rate making for them. It doesn't go beyond anything that they would be okay with, essentially. So that is where the utility themselves are enforcing their equitable mindset via commission proceedings. So it depends on the program. I would also say for California's fixed charge, that was enforced by legislation that then the commission then handled the proposal side of things, and they ended up with like a three tranche program that differs based off of your income and differs based off your participation in statewide and utility low-income assistance programs that already exist. So, but I also say that in the case of California, just as another example, Pacific Gas and Electric, because they wanted to, or the commission specifically also enforced PIP programs. So I think that was without any sort of legislative push, and that's now on uh, a pilot phase that will eventually turn into a permanent program, depending on how this program ends up working with the utilities. So it depends on the kind of equitable rate making that you're talking about.
Thanks. At some point, I'd love to get some of the state by state breakdown. I'll email you separately. That'd be real helpful for the project that I'm working on.
Yeah, no problem.
Thank you all. We have time for one or two more questions. So I see this one here. What can people in red or purple states do to advance energy justice and rate and public utility commission decisions?
I'm happy
Participate.
to go ahead.
Go ahead, Diamond.
Yep. I basically was I was going to say, no matter what your political views are, I think everyone just wants a lower energy bill regardless, right? And so a lot of people just one they don't understand and know that we vote who these individuals are. We vote in who makes the decisions of what exactly our energy bills look like every single month. So really just participating and making sure that people are aware and knowledgeable about these processes and have access to be able to participate, to get downtown, to submit public comments and everything else.
Yeah, I mean, Diamond raises an important point. There's obviously, it takes a lot of effort and help to actually participate in these regulatory proceedings. And there's ways to do that, and Diamond's group is one of them. But also in the states where you elect your utility commissioners, make sure you vote and make sure you know who's on the ballot, before you go vote, as opposed to like get there and say, oh, wait, I didn't look up all the different utility commissioners. They make a big difference to your lives.
And I'll just add for states where you're not directly voting in your commissioners. I know in North Carolina we have our carbon plan proceedings, and those happen, I would say, every other year. And those are for the public. They're essentially in some of the big cities like Asheville and Charlotte. And so if for this current carbon plan proceeding, those public hearings have ended, but the next go round, since this is a constant proceeding that opens up every few years, you can participate in those as well. And there are different organizations in North Carolina, much like Diamonds in Georgia, that are helping get people to those public hearings and to voice their concerns because the carbon plan, even though it's not a rate case on its own, it does inform rate cases and does inform what the utility ends up doing to combat whether it's a future load growth from data centers or whether it's manufacturing load growth or perhaps even these additional hurricanes and the strength of these storms that are coming in and responding to the current concerns as well as what the concerns might be in the future. So it's always important, as Alexandra and Diamond mentioned, participate whenever you have the chance to participate in these public proceedings.
All right, super quick. This question has an extra thumbs up, so I think we should go with this one to wrap up. Can we demand that Duke builds solar and wind because we are the source of funding? It's our money.
Well, I think to kind of reiterate what I said, um, if you want to demand what Duke Energy, like what you want Duke Energy to do, those public hearings in the carbon plan are the best opportunity for you to voice your concerns, especially if you're from a disadvantaged community in either Eastern North Carolina or now in Western North Carolina. Um, those are opportunities for you to tell Duke Energy what is it that you like to hear. Now, it doesn't mean that Duke Energy will actually listen, but the more and more people show up and the more and more voices are heard, they can't kind of turn away from you, especially as more and more concerns from load growth and storm concerns and recovery costs are increasing in the state.
And then also in proceedings where they're trying to recover costs or put together an integrated resource plan that involves a lot of fossil fuels, to the extent that there are experts and advocates who can actually show that there will be lower rates if we have clean energy. That's a good argument. I mean, PUCs will say we're economic regulators. We don't get to make policy. So obviously going to the legislature to create a renewable portfolio standard is a way to do this, which lots of states have. They don't have that in Georgia, but to the extent you can make economic arguments and show why these are low cost, that is going to be much more appealing to regulators. And I've seen that happen in a lot of states where you have environmental and energy advocacy groups who are able to work with economists and engineers and experts to put together reports to show the utility that there are alternative, less expensive plans. And the commission says, yeah, we should do that. Utility, do that. I mean, the utility, remember, the commission gets to tell the utility what to do.
Thank you so much. And we'll go to the last slide. If you didn't get your question answered today, feel free to email anyone on the panel or myself. I want to thank you all. Thank you to our speakers and folks who joined us today. Please expect a follow-up email from us in the coming days with relevant links and a recording. Again, thanks so much and have a wonderful rest of your day.
Bye, everyone.